Well, good afternoon, ladies and gentlemen. It's my pleasure today to introduce you to our guest, Kelli Roberts. And we're going to do something a little unusual today. We usually have both people on the camera, but technical reasons have prevented that from occurring. So you get to see me, but you don't get to see Kelli. And she's definitely better looking. So, welcome, Kelli. And I'd
Thank
like
you.
to tell the folks a little about who you are, what you've done, and what you're doing, and then we'll talk about some specifics.
Okay. So I started in the adult industry on the business side of things in 1996. I did marketing for studios where they paid me to promote their videos. Then I worked with several companies where we made like multi-million dollar big budget movies like Babe Runners and Catwoman. So eventually I took that information and knowledge and experience and began working directly with the performers as an advocate and sort of helping them improve their career, working with their OnlyFans, things like that. So that's how we got here today.
Well, when you say adult industry, that's a term that's relatively new. And by the way, I have an entertainment law background. I was head of business affairs for Warner Brothers for a number of years and represented a lot of unions, managers, and agents. I know we're going to talk about recent California decisions and your article on the subject. And so we can at least talk from an intellectual side also. But
Yes,
adult education is sounds a whole lot better than porn.
well,
I mean,
that's
that's their, and
very
that's
different kind of movies than Warner Brothers. Yeah.
well, the use of the term is relatively new.
Yes.
And even if you go back to the United States Supreme Court and its early decisions regarding free speech and the like, I think
Hmm.
one justice said, I can't define porn, but I'll know it when I see it. And the reality is, it's porn. You can call it whatever you want.
Yeah.
And in fact, I represented one of the big porn movies. I was a lawyer for Deep Throat.
Oh,
So
really?
yeah, I was. And
I worked for the company that made Deep Throat the the newer version, Deep Throated. So
I actually had the director's family on my when I had a radio show, and we kind of talked about that. It was interesting because I remember vividly being in front of not me personally, but me sitting outside the grand jury when they were basically pursuing the people who were involved in the creation of that movie.
that
And
was
some of those issues have evolved from then to now. Almost everything was illegal then,
yeah,
and
absolutely.
now I think we've kind of gone to the other side of the spectrum, where almost everything is legal, except for child pornography. Everything is pretty much acceptable under the guise of free speech. So you talked about promotion. First, you did business with the companies
Right, the company
and
themselves, correct.
what the producing companies that made these movies.
Able Video, Bluebird Films, Amateur District, yeah, the company, the studios.
Okay, so the people who were financing.
Yeah, they were the studios. And then once the movie was made, they would come to people like me and I would promote the movies and then I would get a commission.
How would you
And
do that?
I was in on the early days of the internet. I realized that where other traditional DVD or VHS salesmen back then were selling the movies, I was like, you know what? I think men might be interested in the girls, like their fan base. So I took a different approach to marketing of their movies. I'd be like, hey, look at this movie starring Devin or Savannah Sampson. And it didn't matter what the movie was, I was promoting the girl. And that really resonated with customers. And my sales were extremely good. So then I got hired by a big studio out of the UK called Bluebird Films. And I got sort of in on a big budget productions. Like, I mean, it was the first time I'd ever worked with a company that spent over $1 million on an adult movie. And that's to spend $1 million on a porno is crazy. In fact, on one of them, we spent over $3 million. And that Babe Runners, which was a Blade Runner parody. And it was, I got sort of a different insight to the production side of things. And now that we have OnlyFans, I'm able to work with girls and say, listen, this is what works, this is what doesn't work, this is, marketing basic information, but also legal information. Like you were talking about obscenity. Pornography is legal, obscenity is not. So in one of the movies of Bluebird Films, the girl was asleep, and that was the setup. It was a fantasy. But because she was asleep, even though she wasn't really asleep, in accordance with the law, she couldn't consent. So they spent all this money on this movie that this girl, we couldn't release the movie because in this fantasy sequence, she was asleep. Well, a girl sleeping can't consent. So therefore, that made that scene obscenity. So I'm able to take that information and work with girls today on OnlyFans and say, hey, this is what's legal. This is what you can do. This is the area you stay out of.
So you tell them they can't sleep on the job.
Yeah, that's exactly it. Mattress access.
Bottom line, one thing about the law, and I've been in the law for a long, long time, is it's not only evolving, but concepts change from time to time.
True.
And what was once constitutionally protected is no longer, and vice versa. I mean, that's what's going on. In fact, one of the reasons that we invited you today is because of some recent California cases and an article that you wrote on the subject, with which I have pretty good familiarity, having been there. And I represented 2 unions after I left Warner Brothers, and I represented managers and agents and people like that. So I am familiar with the code sections and whatever. And I personally, and I don't give opinions generally, but on legal issues, you certainly have a variety of different opinions. I don't necessarily agree with the decisions. In fact, I feel that the decision should have been contrary, but it is what it is. So tell us about the case or the cases and your article.
So what we have is in mainstream, and that's what we call like the Warner Brothers Hollywood people, we call them mainstream actors. In porn, it's a very similar setup. You have an agent, and an agent books you on a job, and then you pay, as the actress, you pay him your commission, 10 to 15% of whatever it is that fee is. Well, what agents were doing was they were what they call double dipping. In addition to charging the actors, they would go to the studio and say, well, if you want to work with our girls, you got to pay us a booking fee. It used to be $50. By the time it was all said and done, it was usually $150 per scene. The Department of Labor was like, no. That's not how it works. If you don't have the way the article read is different. What it really comes down to is if the fee is not in writing in your contract, you can't charge it. If you don't put it in advance when that girl signs a contract and say, every time you wear blue, I'm going to charge you $50, then you can't charge her $50 every time she wears blue. And agents were doing it anyway. And as a result, they got away with it for 15 years.
Well, let me ask you the hypothetical question, the academic question. Let's assume for the moment, and I basically supervised the legal department when I was at Warner Brothers, and the reality is that language is capable of being interpreted, and sometimes it's ambiguous, but the reality is if it's in the contract that the quote agent, and there is a difference between the agent and the manager,
correct.
If it's in the contract with the studio or the company that's producing the product, is it enforceable?
If it is in the pre-approved girls contract with the Department of Labor, yes. They determined, the Department of Labor said if it's in the contract, you can enforce it in advance. You can't later just add on fees. And so, yes, they did determine that that is enforceable. But the catch to that is now it's opened up a little bit of a loophole, a little bit of a holy crap moment, if you will. So some of these studios have worked with agents for 10, 15 years. They're like, well, over the last 10 years, you've charged me, and they start doing the math. Oh, that's $34,000. The Department of Labor has determined this illegal. We want our 34,000.
Well,
That has a
reality is, and my major job, in addition to the administration of the studio, was negotiating these contracts.
yeah.
And even though I didn't prepare the documents, it was done by the legal department. The reality is, if you have it in the contract and it's not violative of public policy, it's enforceable. So what doesn't this look? It looks to me, without really digging into the actual language of the opinion, it looks to me that every studio is going to have a provision in their contract, which will be attested to probably by the artist. And so isn't this really an academic exercise?
Well, in this particular case, it's a little bit different because in the adult industry, we don't, it works different. So you have studios who are independent and there are no contracts. You're a 1 day shoot. You're there for 1 day for $1,000. The contracts are between the agent and the performer. And the agent could add that wording in there, but it's too late now. Like it's cat's out of the bag. It's done. All these other, maybe in the future they can go add the wording in there. But for all those other contracts and all those past years, and they've deemed it retroactive. So if you previously charged the studio fees of $10,000, the California's like, no, sorry, that's not legal, and they could now sue.
Well, as a general principle of law, we're not going to get into the real details. There's something called an assignment, and you can make contracts for the benefit of what's called a third-party beneficiary. Mm-hmm. And those contracts, unless they violate public policy, are enforceable. So if I was to be giving advice, which I'm not, if I was to be giving advice, I would say to the agent as opposed to a manager, because agents can charge a commission, right. Managers cannot. And right. That's why for years, they kind of honored that in the breach. They called themselves agents because they had a commission. If they were managers, they couldn't. And there's a whole body of law on that subject. The reality is, in the future, some lawyer, some entertainment law firm is going to make sure that the agency contract with the artist is going to include the ability and the right to have an assignment made to the company. I don't want to call it the studio. Yeah. The company. That's what's going to happen. So this opinion, to me, off the top of my head, obviously I haven't done any research, but to me, this is an academic exercise. And you're talking about the Labor Department as the initiating entity. Yes. It's a bureaucracy. If you ever dealt with the Labor Department, you know that it's not exactly the exemplar for the legal community. So the bottom line is, I think this probably is not going anywhere. But that's just my opinion.
And the adult industry works very differently now. Prior to the introduction of OnlyFans, this issue would already have fought an appeal immediately. But now that OnlyFans is a thing, people are scrambling to get big name talents on set in the first place. So people are being very careful not to rock that boat because you want that girl on a set. And if you're going to argue with her over $50, she's not going to show up.
Believe me, I'm sure there's plenty of people online waiting for this gig. So I don't think it's going to scare off people because there's an assignment clause allowing a third party to collect from a party that's not in their contract.
On bigger, and again, we're talking a difference between mainstream and porn. There's only a handful of agencies anyway, and a couple of them are going to go to have their contracts redefined that says we can collect this fee. But as of now, and we're talking June 19th, it could absolutely change in a week from now. But as of right now, nobody is willing to rock the boat because there's so many other age verification issues, obscenity issues. Everyone's just really scared. And nobody wants to rock anything because keep in mind on that ruling, the two cases that they're talking about, that one agent just got himself out of prison over this ruling because there was an associated criminal case with that ruling. He literally just got out of prison. And then the second guy, he's completely out of business now because he got caught hiding cameras in the bathroom at the model house.
Yeah, I saw that. And the reality is, much ado is being made about this issue. Of course, it matters to you because it's your industry.
Right,
But the
right.
fact of the matter is, language is subject to interpretation. And the lawyers that are in the entertainment law business are going to make sure that it passes muster and does not violate any of the actual holdings to the extent it can be interpreted. And they're going to do what they're going to do. And I would imagine, I don't really know. And the fact is, there's probably lots and lots of entertainers, for using that word, who are going to say, well, I don't care if you collect money from somebody else, as long as it doesn't hurt me. As long as it's not going to affect my income, who gives a damn?
And here's the interesting part of that. That booking fee, even despite what the Department of Labor says, never affected the girl. It never came out of her money. That was just a fee paid by the studios. So it was a weird ruling anyway. The girls never got charged that $50. They were their rates are their rates. They get $1,000. They get $1,000, and that was the oddest part of that whole ruling, that they acted like they were doing something for the girl. If you want to do something for the girl, force the studios to pay testing fees. Like, taking away the booking fee from the studio booking fee is not going to help anybody.
Look,
So
when we used to do film contracts, one of the major issues of contention, for those of you who would like to know what goes into those kind of contracts, it's about leverage. And the reality is that the studio, if you want to call it that, the studio is going to do what it's going to do. It's going to design the language that it wants to design. They'll call it whatever they want to call it. But the fact is, the biggest contention over all the years I was doing it is the question of what they would refer to as overhead. And the studio would charge for just about anything you can imagine. And I was telling the story to somebody yesterday that I had a conversation with Kirk Douglas. He was an actor that was obviously working on a picture at Warner Brothers. And he called me one day and he said he wanted a white picket fence around the trailer because they were shooting in the desert, because he was bored when he got up and all he could see was cactus. And he wanted this. And I said, it's not part of the budget. He says, if you don't put it up, you know what's going to happen? I'm going to have a very bad headache, and it's going to cost you X dollars a day while I'm not working. So I drove out to Palm Desert, and I agreed. We put it up. I gave it to him. About 3 months later, when we were doing post-production, I ran into him on the lot, and he was complaining about how the studio was cheating him of income by boosting up all the overhead. I said, let me tell you something. Let me remind you about the white picket fence. You know what? You paid for it. So the reality is, when you are looking at a contract, people with the most leverage get what they want. In fact, John Wayne had the only contract that I can remember that provided for payment on what's called the gross income.
Yeah.
Before the overhead. Because every time you were shooting a movie and you wanted to do whatever, it got charged against. It's the same thing, by the way, in the record industry. I represented Martha Reeves from Martha and Vandellas. And we had that lawsuit with Motown over the outrageous overhead charges. And so the point I'm making right here, maybe not clearly enough, is that the people that are going to do this business, they're going to craft language, is going to do whatever it is that they want to do. And if the girls want to walk off, they walk off. We'll replace them with somebody else. That's the way it works.
For now, nobody's willing to rock that boat over $50, but you are right. It is going to happen. Is it going to happen tomorrow? Probably not, because people are really still freaked out with other issues. And OnlyFans is a big one. Like, you have a girl like Adriana Chechik or Riley Reid. They're making almost $1 million a month. They're not going to go sit on a set for 8 hours for $1,000, because these girls don't get royalties and residuals in porno. So they're going to sit at home and make their $1 million a month on the OnlyFans. They don't care what the studios are doing. It's a very weird world in porn versus mainstream. But
I'm not so sure it's that distinguishable. The artists are the artists. And in fact, I was telling somebody last night, if they don't like it, don't sign the contract. Go
That's
somewhere else. And we did
exactly.
that with a major star. And I couldn't make a deal with the agent. We had a falling out over credits. And the reality was he didn't get the guy. He didn't get the gig. We didn't
Yep.
make a deal. I said to him, this is it. Take it or leave it. You don't
Yep.
want it? Go somewhere else. There was only like 5 major studios at the time. I
Yeah.
said, go down the street to Paramount. I don't care what you do. This is the deal. Take it or leave it. When you have leverage like we did
Yeah.
in the olden days, you have leverage like that, you have the ability to control the situation. And that's what people are going to do right now, right after that decision was affirmed. People are rewriting the contracts, and they're damn good lawyers. The people in the entertainment industry,
Oh
not
yeah.
only dealing with copyright and dealing with intellectual property, but it's a very broad subject. I didn't mean to use the word broad because we're talking porno, but the, the reality is they're gonna deal with this just like they deal with everything else. If you look
It
at rights of privacy, that has evolved from Griswold, which was a case of basically a Fourth Amendment case, and it evolves to get the view of the then majority of the appropriate court. So I think it's an interesting subject, but
is.
not that interesting.
Yeah, it's not. It's a great what we call clickbait headline. People love to read about it, but on a legal standpoint, you're correct. Studios hold the power because they have the money, and if they want a clause in there that says, or your agent, they want a clause in there that says every time you wear blue, you have to pay me $50. And if the girl doesn't want to sign it, she doesn't have to sign it. But if she signs it, she does have to stick with it.
That's exactly right. So don't you think that makes this conversation kind of academic?
It is, and that's really this is a sort of academic exercise because, and I teach girls. This is what I teach girls, OnlyFans girls who have never been in the industry, and they are going into this blind. And I say, if you sign that, if you sign your name, it doesn't matter what you have trademarked. You've given up your rights. That's your rights. You don't sign it then. That simple.
Well, actually, it's not totally unlimited because even the Supreme Court cases that have come down, and I've read them over the years, uh, are subject to interpretation, and changes are made all the time. In fact, the cases that were dealing with the Civil Rights Act were totally reversed. Look at Roe versus Wade. It had been the law for 50 years, and all of a sudden, boom, it was something else. And so I think there's very little money involved in any of this. If you're talking about $100 or $200, who cares?
Yeah,
And really, who cares?
and it doesn't even affect the girl. That's the thing that the labor board's over there doing a happy dance, like they just did these girls a favor. They did nothing for these girls. It never came out of their check anyway. It did not matter. It was only the studios that were charged this little, in some cases $50 a day, and it was ridiculously stupid. No girl benefited from this. No girl will benefit from this. So the labor board has been a point of contention for many of us in the industry because they're supposed to protect us. That is,
Well, I don't want to be overly crude, and I'm thinking about whether I should say this or not. But with in your industry, we were talking before, it's about the fucking overhead.
it is. It
It's
is.
what it's about.
It is.
It's
But
an overhead. It's an overhead item that's going to be attributed to one or the other party,
yeah,
and as long as it's not violative of public policy, and child porn, for example,
yeah.
is violative of public policy. That would not work in one of those contracts to the extent that it would even be enforceable, which it would not. So the reality is, generally speaking, this isn't going to affect anybody anywhere
No,
that's going to have any significance. But
no.
I wanted to have you on the show because I think the public really needs to know the intricacies of various types of businesses. And the show we had just before this one, I basically disagreed probably almost 100% with our guest, but I felt that the public had a right to know what his opinion. He's a qualified, bright guy, and even though I disagreed with him, the public is really entitled, and that's why we have a show that has balance.
Yeah,
We don't pick one side or the other. I'm not political. I'm not a Democrat. I'm not a Republican. I look at it as an intellectual kind of thing. And I wanted to have you on so you could explain this. It's an interesting issue for a 5-minute conversation.
Well, that's true. That's about as far as this will ever go with the end of this
Yeah.
conversation. Some guy out there, and it's going to be some, bigger agent. They're going to have it. That's going to be fixed, but not right now. It's people are a little iffy to touch anything right now because of all the other issues. But it is at the end of this conversation. This will probably be the last anyone talks about it ever.
Probably. And you know what? Hopefully, because it's not worth, basically, to my way of thinking, of course,
It's really not.
it's not worth the time when you have a world in chaos to
It's
sit
true.
and spend even a half an hour talking about a subject like this. I don't really care. And I don't think 99.9% of the public cares. And probably some of the people in your industry don't care either. So, I mean, there's
Absolutely.
talk about limited audience. This is a limited subject matter. So anyway, I wanted to thank you, Kelly. I
Thank you.
appreciate your input, and hopefully we collectively have learned something. So thanks
Yeah.
again.
It was a joy talking to you. Thank you.
My pleasure.